Hello, welcome to David Gray Solicitors. I'm Mehdi Hassan, a solicitor in our immigration team. The firm was set up by David Gray, an immigration lawyer, in 1979. We've come a long way in the last 45 years and established ourselves as a leading law firm in the Northeast and nationally known immigration practice. We have a well-knitted team of brilliant immigration lawyers who can assist clients in both personal and business immigration law. We can advise you in person, via video calls in Teams, by email or telephone. This means that we can help you with your UK immigration wherever you are in a way that suits you best. The team is led by well-respected immigration lawyer Brian West. Members of the team speak a range of languages which enable us to communicate with clients who do not have English as first language. We offer fixed fees for much of our immigration work, so our clients can have peace of mind that their work will be handled by an expert at a cost which is reasonable and certain. Where we undertake work on an hourly rates basis, we provide an estimate at the outset so that there is a clear understanding of the likely overall cost. We're going to discuss the frequently asked questions of some of the popular applications. Please note that the law is subject to change and the information given is correct at the time of making these videos. A person who is a British citizen settled in the UK or has leave as a refugee or humanitarian protection can sponsor their partner. This will depend on their immigration status and whether it allows them to switch to a partner visa in country. For example, visitors are not allowed to switch to a different category. The applicant must not fall for refusal under the suitability requirements and meet the eligibility requirements. There are various reasons that relate to the character and conduct of the applicant, such as criminal conviction, previous breaches of the UK's immigration laws, unpaid NHS fees, etc. An applicant must meet English language, relationship, financial and accommodation requirements. Applicants aged between 18 and 65 need to pass an approved English language test at CEFR level A1 unless they are from a majority English-speaking country, have a degree taught in English, or can be exempted due to a medical condition. The applicant and their sponsor must be in a genuine and subsisting relationship and intend to live together permanently in the UK. Both must be over 18 at the date of application. If the application is as a spouse, the marriage must be valid. If the application is as a fiancé, they must show that they intend to get married in the UK. If the application is as an unmarried partner, they must demonstrate that the relationship has subsisted for at least 2 years. Applicants must meet the minimum income threshold by showing at least 29,000 gross annual income. This can be met from various sources, including employment, self-employment, cash savings and non-employment income. There are exemptions if the sponsor is in receipt of a specified benefit, such as personal independence payments. Instead, they need to show that they can maintain their partner without claiming additional public funds. The financial evidence needed to prove income is specified in the immigration rules, which means it must be provided with an application. If it is not at all provided, then the application can be refused. Applicants need to show that there is accommodation that is available and suitable for them and their sponsor to live in. This can be either owned or rented. They need the owner's consent for them to live there. It is possible for this to be a shared house or room in a family home, provided the couple will have exclusive possession of at least one room and the house is not overcrowded. The reasons can be quite varied given the different requirements that need to be met. However, in our experience, we find that this is usually because the required documents have not been provided to show that the applicant meets the requirements. Example, not providing bank statements showing income deposited. Applicants must ensure all the documents are genuine and any documents not in English are translated. Any false declaration in the application form or fraudulent documents will not only lead to a refusal of the present application, but can also impact future applications. The applicant must not fall for refusal under the suitability requirements and meet the eligibility requirements. There are various reasons, and these relate to the character and conduct of the applicant, like criminal convictions, breaches of immigration rules, unpaid NHS fees, etc. An applicant must be a genuine visitor with intention to leave at the end of the visit. They must show that there are sufficient funds to cover their travel and all reasonable costs associated with the visit. This can be provided by a third party, example a family member or a friend. Visit visas are very difficult to get due to the subjective nature of the requirements. Applicants need to satisfy the decision maker that they are a genuine visitor. There is no list of evidence or documents that can be provided to show this. However, they can show the reason for their visit, example to attend a family wedding, and that they have ties to their home country, such as family and or financial ties, which gives them a reason to go home afterwards. While we cannot guarantee success, as we do not make the decisions, we can ensure that the application is properly presented with as strong evidence as possible to maximize the chances of success based on the applicant's personal circumstances. This is more of an art rather than a science, and it comes from years of experience dealing with similar applications. If you're a national of an EU country, Switzerland, Norway, Iceland or Liechtenstein, and you started to live in the UK by 31st December 2020, or if you're a family member of such a person. The deadline for most people to apply to the EU settlement scheme was 30th of June 2021, but applications can still be considered in limited circumstances. Applicants need to show that there are reasonable grounds for missing the deadline. There is no exhaustive list, but examples of acceptable grounds are medication condition, lack of capacity, or compelling practical or compassionate reasons. You can still apply, explaining why you're applying late and providing evidence to support this. If you have lived in the UK for a continuous 5-year period, you will be granted settled status, that is indefinite leave to remain. If you have not lived in the UK for a continuous 5-year period, you'll be granted pre-settled status. You can apply for settled status after completing 5 years residence in the UK. You do not have to spend 5 years with pre-settled status to qualify. You can apply for EU settlement scheme family permit to bring your spouse or durable partner to the UK, provided the relationship was subsisting before 31st of December 2020. If the relationship was not subsisting until after this time, then an application will need to be made under the provisions to bring partners to the UK that apply to British citizens and those with indefinite leave to remain in the UK. A partner with whom you have lived together in a relationship akin to marriage for at least 2 years prior to 31st of December 2020. There is no fee for applications under EU settlement scheme. There is no set timescale at this moment. There are a variety of options depending on the applicant's personal circumstances. Some visas give the right to work, for example, a spouse or partner visa. Some visas are work specific. Here we will discuss 2 popular work visas, the graduate and the skilled worker routes. This is a work visa for people who have studied in the UK. It is an unsponsored work, so does not require the applicant to obtain an offer of employment from an employer who holds a sponsor license. It is not a route to long-term settlement in the UK. If you're currently in the UK with a student visa and have successfully completed a UK bachelor's degree, postgraduate degree or other eligible course within the last 12 months. You can work in most jobs or be self-employed, but you cannot access most state benefits or work as a professional spokesperson. There is no skills or salary requirement. Your partner and children who are already with you as your dependents in the UK on your current student visa can also apply to stay as your dependents. It is not possible to have new dependents, but they can join you from outside the UK if you switch to a new visa category, example skilled worker. You will be given permission to stay for 2 years or 3 years if you have a PhD or other doctoral qualification. It is not possible to extend stay as a graduate, but you can switch to another visa category, example skilled worker. The skilled worker route allows a person to either come to or remain in the UK to undertake skilled work. It is a sponsored work, so requires the applicant to obtain an offer of employment from an employer who holds a sponsor license. The employer must assign a certificate of sponsorship before an application can be made. It is a route to long-term settlement in the UK. You must be employed in a job that meets the skills and salary requirements. You cannot be self-employed. An applicant must score points for having a valid certificate of sponsorship, a job at the appropriate skills and salary level, and for English language and maintenance. Your partner and children can apply to join or stay with you in the UK as your dependents unless you're a care worker or senior care worker. You'll be given permission to enter or stay for the work dates stated on the certificate of sponsorship, up to 5 years. For dependents, their visa will usually end on the same date as the skilled worker. It is possible to extend a skilled worker visa. After 5 years in the UK as a skilled worker, it is possible to apply for indefinite leave to remain, also known as settlement. Your family members who are dependent on the visa can also apply for settlement after 5 years here. Your employer will have to apply for a sponsor license before they can sponsor you. We can assist the employer to obtain their sponsor license and then you with your application as a skilled worker.